let's talk to the people who are purchasing assets. Okay.
Key terms.
Yeah. What would you expect to be seeing in there?
Well, number one, definition of the assets and schedule of assets.
Okay. So, can you just talk a little bit about why you think that's important?
So usually, so if it's an asset purchase, usually we're not buying the debtors of the business, so what the customers owe the business. So we need to understand if that's in or it's out. Usually it's part of the transaction. We want to make sure we're not buying the debts of the business as well, because we're just buying the assets. We want to make sure we're buying all of the intellectual property. So that needs to be defined sufficiently. What information is being transferred? Plant and equipment. Other than that, we will have quite a few terms about employees and how the transfer of employees are dealt with or not. If it's a business which is, let's say it's a manufacturing business, we'll have issues with stock and work in progress.
Yep.
So we'll have some key terms around that. We'll have terms around the assets being free of any encumbrances.
Okay, let's talk about encumbrances for a second. I've clearly misjudged how much I can write in this space, but let's just talk about encumbrances. For the purpose of that, I'm just going to change my colour. In fact, I've just changed my mind about how I'm going to do this. We're just going to do asset purchases to start off with, and I'll create a new page for the next one. So encumbrances. So what's an encumbrance?
So it could be, for example, a general security charge over the business. Might be taken out by the bank if they have a bank loan they're currently doing.
So examples of encumbrances could be things like mortgages. It could be a PPSA security, so a recorded security. Effectively, we use that term encumbrance to cover the things, any restriction on the right to transfer the thing being transferred free and clear of any rights that other people might have, so that their ownership, the new owner, will get full legal and beneficial ownership. So sometimes, even though we tend not to use the language encumbrance, part of that is about ensuring that the assets that are being transferred are held by the vendor in such a way that they are able to transfer both the legal and the beneficial interest. Now that's important in an asset sale in particular, because it is quite usual for family businesses to be set up as family trusts. So it might be that there is a corporate trustee, but the corporate trustee will hold the assets for the benefit of the beneficiaries, who, now that might be unitised or it might not. So a small business is not at all unusual for the structure to look something like this. So we've got a company that owns assets. And in theory at least, that means that the company can sell those assets to somebody else. But if the company is actually a trustee, it holds those assets, the legal benefit of those assets, but the beneficial interest in the assets is held on trust. And so the trustee, which is actually never spelt with out the second E, don't know why I did that, the trustee can only do things within its corporate power. So again, so what if, look, I know this feels a bit unstructured, but I just want to cover the points as we go. So what if a purchaser, if you are purchasing from a company, you don't know whether they're a trustee or not, why would you make that inquiry, or why might you not make that inquiry? What happens to this contract?
they're acting outside power as a corporate trustee, you might have some issues with the validity of the sale of the assets.
So, and as a purchaser, well, you might be a bona fide purchaser without notice, and that might mean that you have the legal upper hand, so to speak, that the issue then becomes one between the trustee and the beneficiaries of the trust, and you can stay out of it. But chances are you can't stay out of it. And again, a lot of the structuring work and the thinking at the beginning is about avoiding those problems. So encumbrances are beyond just security interests. We need to think about, so who can sell, which is really goes back to your other question.
Can I say, though, that we've had transactions we've been involved in, trust situations, so corporate trustee of the trust, we've never been asked for a copy of the trust deed. And it's never been asked by the solicitors involved. Interesting.
That is interesting. Yeah, so that is actually one of the first things. I would also, but I am assuming that you would be requested when you're acting for a trustee vendor for a warranty from the trustee that says that there has been,
Absolutely.
and look,
But there's usually not a reading.
sorry, I didn't finish that sentence, and because I didn't finish that sentence. I just want to make sure that everybody's on the same page. What I was going to say is a warranty that says it's given by the trustee or by the vendor, saying that they are acting within their corporate power. So let's think through that strategically. If you have that warranty, but you haven't seen the trust deed, what is your position as opposed to if you have that warranty and you have seen the trust deed? What might your strategy be?
If what, sorry, you have seen the warranty?
So our options are, as a purchaser, we can get sale and purchase of assets agreement that includes a warranty from the vendor who is disclosed as a trustee, but the warranty is given by that trustee that they are acting in accordance with their obligations as a trustee, which come from the trust deed. Why might we not want to see the trust deed? Why strategically? Yeah, because you don't want to be on notice, and you don't want to be spending your valuable legal dollars getting an opinion in relation to the trust deed. And if your purchase price is structured so that there is a withholding of some of that money, so it's actually easy to address that, or if you have some kind of insurance in relation to the warranties, which is not an unusual way of structuring these transactions these days, you've got a relatively easy way to recover.
So size of transaction as well. So,
if
it's a lot larger, you're more likely to be looking at the trust deed.
Personally, I would be looking at the trust deed. I've not done a transaction where there is a corporate trustee where I haven't looked at the trust deed, and I still have required that warranty. And when the trust deed has a process for getting those kind of approvals, if there is one, then I'm wanting to see evidence that those approvals have been done at closing. But I can see strategically why in a smaller transaction where, and we spoke about this right at the very beginning, materiality is a really interesting idea that you can't look at everything. And when you're doing your due diligence, you cannot kick every tire and check every entry. So you come up with this idea of a materiality threshold. I am going to look at the things that will impact the transaction by a percentage. And we usually use a percentage of the anticipated purchase price. So if it's a $100 million transaction, we are looking at things that will have an impact of $5 million in most cases, other than really qualitative things where we can, like we know, for example, that, if we have sexual harassment issues in our employment team that haven't been addressed, or a toxic culture of some sort, we can't necessarily quantify that. There might not be $5 million worth of damages, but the impact on our the workloads that follow, and our reputation will be significant. So we might pick some additional things that we will look for. But sure, $100 million, like $5 million is still a pretty big deal. But if it's a $5 million transaction, then we're looking at issues that are at what? 250,000. Sorry, I can't do the maths in my head today. I went to a party last night. 250,000. If it's a $1 million transaction, then we're looking at issues at, $50,000. So much smaller. So you've got to kind of pick your issues because it's a smaller transaction, but you might have more things to look at as a consequence of your materiality thresholds. It can be quite interesting. So, okay, I just want to continue on with you. There are a couple. So basically, I didn't write down all of the kinds of things you were looking at, but defining what the assets were was really the key feature that you had here. What other things? So you're defining them, and you're looking at potentially warranties that are associated with those.
Warranties was the next.
Yeah.
Certainly. The warranties won't be as extensive as a shared celebrate. They'll still be there.
But we're just talking about the material terms at the moment, so you can anticipate that there might be later on some more detail, but there might be some pretty key warranties that you'd be looking at the beginning. For example, you, Mr. or Mrs. Vendor, have all of the power and authority to transfer this stuff to me. Encumbrances, you would be working out what they are, and you would be matching that with a warranty. What else?
Structure of the actual purchase price or the consideration.
Okay, so price. Price.
And on what terms?
Price and terms. Okay, I suspect we'll talk about this with more people, so we'll continue on.
Conduct of the business pre-completion.
Excellent. So again, that's something that you want to get in really early on. So basically that's how is the business going to be run before we purchase it. How do you see that working? So what kind of things would we be talking about?
So normally what we would see is there would be conditions around the kind of decisions that they can make during the period between contract execution and completion or settlement. So it might be before you hire or fire any new employees or employees. You need to ask us first before you go and spend more than X amount of money or make a commitment of more than X. You need to ask us.
Before you take on contracts of a certain size, before you take on new clients. Okay, absolutely. All right. I suspect that we're going to come across more things as we go, and I suspect you guys already have some more things. The other two partners in this firm want to add anything at the moment quickly? Because I'll...
we channel most of it.
All right, okay. Well, so you guys are from the litigation team. I'll come back to you later. This is the corporate team here. Okay, on the other side of the transaction, as the vendor of assets, firstly, before we talk about things that are specific to you, is there anything that was on the list that you're corresponding... Oh, sorry, you're the vendor.
Yeah, we're the vendor.
You're the vendors. I'm looking at them. Are there... as acting for the vendors, is there anything on this list that the purchaser wants that you would be worried about?
Obviously, warranties is a big one, and we're talking about definitions. We're talking about the terms of the sale. Definitely conduct of business prior to completion.
So would you be expecting to see that in? Would you want that in the agreement, or you do want it in?
You would want it in so that your obligations as the vendor are clear.
Yeah.
So there's no ambiguity in case of a disagreement.
Another reason why that's often really important to vendors, and why often there's a little push and pull in the negotiations around that particular area, is for the kind of reasons that Ashley was talking about earlier. the new owners coming in and looking at stuff and talking to people is really upsetting to the employees. And also, unless and until you're ready to tell your employees what's going on, you really want to keep those people at bay and outside, right? So being really clear on what the rules of engagement are in the lead up can be really important. It's one of the few areas where I have experienced some really high levels of emotion in the negotiation too. And as lawyers, on the whole, well, particularly those of you who have a bit of a commercial bent, we're not really used to dealing with highly emotional people around a board table like this, but they can be. And it's something actually I think we need to prepare ourselves for as practitioners. And it's often something that the junior lawyer isn't expecting, because the senior lawyers kind of get used to it and we forget what we don't know. So that can be a bit of push and pull there, because the objectives that your client has are quite different from the objectives that their client has.
Yeah, and particularly with dealing with private businesses, you are talking about a person's livelihood.
You are. You're talking, and also it's their thing, it's their baby.
And it's a very emotional thing for them to decide to sell or to
absolutely
go to some other stage in that business. So.
Absolutely. And, you know, often, particularly when we're talking about a family business being sold, there will be there will be all sorts of connections too. There will be some people, family members who will continue on, some who won't. You know, mum selling this business may well have spent more time with her software developers than she did with the children who are now going to benefit from this. It can be a very emotional place.
And that leads me on to one thing I'll suggest that could be in a contract is ongoing assistance after completion. So who's going to remain involved? Are there going to be any restraints on the people that were involved that won't be involved anymore?
So there's two sides to that.
Yes.
So excellent point, Carly. So I did stop these guys. So from a vendor's perspective, one of the things a vendor may well be wanting is that ongoing assistance. If we can't find something, if the tax office comes a knocking and they want to look at something, probably more relevant to shares for them from that point of view. But if a machine breaks, could be anything really, we want to be able to ask questions. We want to work out how your filing system works. If we need to get access to computer records or backups or something for customer records, we need that assistance. But a vendor is like, actually, I just want my check. I'm planning to be in Cambodia, running half marathons, high-fiving kids in temples. I'm not interested in helping you out with that stuff. So what will that involve? Yeah. Also, again, just going back to contract principles, when can you add a new term after a contract has been signed?
Depends on the agreement to be made.
Basically, yeah, it depends is the best legal answer ever, but the short answer is no, you can't, because once you've got a contract that has been completed, a contract is made and you need new consideration. A contract may include a variation mechanism though, but a variation, we're talking at this stage, at the really early stage of indicative bids, what kind of things do we need to know about? What would we be looking at? Being able to vary it down the track, particularly for bringing in, getting humans to do things, humans who are unlikely to be parties to this contract, remember, too.
We had this issue come up. We had the director of the vendor company,
Mm-hmm.
and you can't just simply say in the contract the director will be available post-completion. You have to consider they're not a party to the contract until you make them a party.
So again, one of the things we will need to consider as you're looking at this, do you need a side agreement with the individuals who you need to ask to do things? Or do we need to have, do we need to make them a party to the overriding agreement, particularly when we're relying on information that they've given us? And will they agree to do that? And what's the consideration for them doing that? Again, it's really just thinking back through the contract terms. I mean, really what we're doing here is thinking about what a contract would need to contain.
From my experience, it's better not to actually get involved, because a lot of companies who actually purchase large companies, they can't, especially smaller ones, they don't know how to run it. So it might actually be.
Well, remember, you've got a listed company purchaser in this case, but you're right. You're absolutely right.
Back and purchase it back, you know.
And that will often go to price terms. So particularly if we have an earn out or something like that, which we'll talk about as we progress through all of this. So the other thing that Carly mentioned is restraint. So because you're acting for the purchaser.
Can he go and carry on another business which is similar to it?
So you are going to be very concerned to make sure that their client, well, first you're going to want to understand what your client's motivations are. But if your client wants to employ key members of the staff, then we need to have that as part of our arrangement. But if they want to just take over the business and continue to run it, they want to be sure that that their client, that the vendor, isn't just going to set up shop under a similar name in a similar area doing a similar or even the same thing. So again, some contract law principles again. Can we specifically require humans to do or not do things?
Only if they're a party to the contract.
Well, only if they're a party to the contract, but on the whole, we can't make employees do anything, right? We cannot specifically enforce a contract of personal service. So equity will not provide that remedy. We can, in theory, though employment law makes it quite difficult, if an employee breaches a contract, from contract law theory, we can sue them for breach of contract. But recovering damages from an employee is actually a very, very difficult thing to do. So with restraints, there is a greater ability to restrain an employee from doing something than there is to specifically make them do something they don't want to do. But an employee, and that includes a former employee. So we have to think through who will be the parties to these contracts and who will need to have that right and who they will affect. So that will impact the structure as well. So let me just add restraint.
We've also already got warranties up there, but we don't have the other side of that. We don't have indemnities, which as a vendor, you're going to want to know what you're going to be up for if something turns out to be wrong in the future.
So again, the detail around indemnities and what the language we would use are caps and collars tends to be negotiated later, though in an indicative bid, it's not a bad thing to say, okay, and this goes, we didn't really talk about price and terms, and this applies on both sides, but to say something like, we will offer you, the price will be $10 million, subject to adjustments for the value of stock on X date. So we will do a stock take. So plus and minus creditors if they're in. So there will be some maths effectively that sets a base price and the adjustments. And it is likely that a vendor who is seeking bids would put a contract like the one that you guys have been able to look at into the bid pack and say, we want you to bid based on our version of the contract, which would, so then you're basically comparing prices based on what those adjustments are. It would also address, you might want to address how much of the purchase price will be paid upfront and how much, if any, would be withheld, and then the basis on which deductions could be made from that withholding for breach of warranty. So effectively, how much of that withheld purchase price might be effectively a prepayment for the indemnity or security for the indemnities, or whether you would have that as a separate indemnity, or whether or not you're going to seek some sort of warranty insurance, warranty and indemnity insurance.
They have a time limit on the warranties.
Yeah. time limit as well. Again, a lot of that tends to be negotiated a little bit later on because you want to have a look at the due diligence in some considerable detail. But they're the kinds of things that we're looking at.
Probably another thing we would add as well would be an indicative treatment of debtors, creditors and contracts. They can be extremely valuable things for businesses, and understanding at the early stage what that treatment might be would inform the later negotiations between the parties, whether there should be later negotiations.
Yeah. So part of that too, sorry, this is very messy, but it's there to really help the recording more than our conversation. So one of the things that can be interesting there is, particularly if you've got a very large business with large numbers of customers, part of the due diligence will be around doing sort of ad hoc look at what the treatments are. And we spoke a couple of weeks, when we met last time, around looking at ratios as well. So you might be in the due diligence looking at the historical, what percentage of creditors pay within a particular period of time. And then you would be looking for warranties about the consistency of that. And as a purchaser, you would be, you want the business, or you have a belief as a purchaser that that business is worth more to you than the cash you've paid for it. And the vendor presumably believes that the cash that you're paying is worth more to them than the business that they're currently operating. And as a purchaser, your client is coming in thinking, well, these are efficiencies that we can bring. Like, we're really good at debt collection, so we're going to reduce that number, which means we've got more money in the bank. Or we've got a good relationship with a factoring company, so we're going to factor that debt in some way. So you would be dealing with it differently. Does everybody know what factoring is? So factoring is effectively selling the receivables in advance. So if you've got $1 million worth of receivables, you might take $975,000 from a factoring company that then effectively owns that debt, and then they recover it. It's just basically a way of financing. And you tend to have rolling factoring provisions.
Again, at the early stage, you might be interested to see what the conditions precedent are. Obviously, this is something that's
I'm going to move to a whole new page for this. So conditions precedent.
This is something that you'll probably work out later on, but you might want to know as the vendor what could stop a deal taking place.
Yeah. Well, one of the things it might sound counterintuitive, but one of the key things I think a vendor needs to know is, can you afford it? So our purchaser is a listed company. So there are a couple of things that we need to know here. Because as a listed company. So as a listed company, we might actually be able to look at their disclosed accounts and see how much money they've got in the bank. So we might not worry about it terribly much. But if they are financing it, it may well be that they also want this to be subject to finance. And you need to know before you go terribly far as a vendor, can they finance it? The other thing, because our purchaser is a listed company, the listing rules say that if you are going to make a major change to your business, then you can't do that without shareholders' approval. That's the shorthand way of looking at it. So I think it's chapter 7, significant transactions. I may have given you the wrong chapter number. They're all sort of 6 and 7 around there. So the question becomes, is this a significant transaction? And if it is, then the conditions precedent to the transaction going ahead will include getting the shareholding approvals that are needed under the listing rules for that transaction. Now, we've purposefully here chosen a transaction that wouldn't fall within the rules. I just want to point it out that it's something that you would need to think about there. If it was sorry? Please.
Why is it that, say, for example, the purchaser has upon it a condition precedent that it will have the money to effect that transaction or have finance arranged, are there any warranties then attached to that condition precedent, or it is just a
So there is some
binding it?
I'm clutching at my memory for the name of the case, but there are some cases that go along the so Professor Finn or Justice Finn's duty of good faith in contracting, kind of those cases, will show you that or suggest that if you enter into a contract where there is a condition precedent, that you have an obligation to try and fulfill that condition. Usually that's actually dealt with contractually anyway, that if there is a condition precedent or there are conditions precedent, the provision itself will require the person who is required to do the thing or get the finance to specifically take all reasonable steps, or even best efforts, but best efforts, best endeavours effectively mean reasonable steps under Australian law anyway.
So you're subject to finance clause and then just sit back and do nothing.
Yeah.
And say, oh, we didn't get our finance.
Yeah,
We're
right.
pulling out.
And there are definitely cases that show that if the other side does things, if the other side wants to get out of the contract and does things
to frustrate
specifically
the achievement.
frustrate the achievement of the condition precedent, that will be a breach. And there is also there are many decisions that show that a party who has the benefit of a condition precedent can waive that condition. So a subject of finance clause, for example, if the purchaser can't say, I don't think you got finance on reasonable terms, so the contract is over. It's up to the purchaser to determine whether or not the terms that they've received are reasonable or not. The vendor, it's like nothing to do. Did I say purchaser the first time round?
Yeah.
Cool. Like I said, bring on the robot teacher. Like clearly AI, I don't even have actual intelligence, much less artificial intelligence today.
And smaller private transactions, I just, from my experience with dealing with transactions, I want to, if I'm acting for the vendor and I'm the vendor, I don't want conditions precedent at all. I hate them because they're going to get in the way of a quicker completion of the contract. It'd be very unusual for us to be suggesting any conditions precedent, even around finance, because it'll just be a subject of finance clause anyway.
So let's talk about that. Assets or shares, there is a particular circumstance where a vendor will usually need a condition precedent and need to be putting it up front. Can anybody think about what that might be? There are a couple of them actually, but
It could be if they have a major new contract, for example, coming up, and they may need a condition precedent around whether the transaction is going to proceed on the basis of whether that happens or not, because it may materially change the business.
absolutely. And even with material contracts, including things like premises leases, or significant supply arrangements or significant ongoing customer arrangements may have change of control provisions in them. And so the vendor may actually have to come open-handed and say, the sale of this business will be subject to my customer, my landlord, my supplier, my key supplier agreeing to a change in control. So think about it, a franchise agreement, for example. If I want to go and buy a McDonald's franchise from a current franchisee, the transfer of that franchise contract will require the approval of the franchisor. And so the vendor will be saying right from the very beginning that any sale will be conditional on that agreement, because otherwise they will be in breach of their own agreement. So, and it's very, very common in premises leases. And I said at the beginning of this is relevant whether you're acting in an asset transfer or a share transfer. How can that be? I mean, when you sell the shares, you get everything, right? So you would just get the contracts. So why have I said that?
Is it a question
'Cause I'm an
of whether
idiot, you know.
can be a new party to that contract?
Well, think about it. If we've got a company, and the company is a party to a contract, so
It's not like that.
Great.
okay. Oh, sorry, wrong. That's why. You'll get it later. I can't see that far. One of those buttons says next slide. Which one is it? Oh, thank you. Sorry, it's a very long way away for these tired old eyes. So condition 3, so I've got a company that's party to a contract. We've got shareholders here. And so the other party to the contract, we'll call it other party, very creative here. If we get rid of those shareholders and put in a new shareholder, doesn't affect that contract at all, does it? Because the parties to the contract are the company and the other party. So why would, in that situation, our company that is selling say, I can't so I buy the company that is a party to the McDonald's franchise agreement. Why do I need the franchisor's consent?
Potentially be shareholders interest rights.
Could be. It's pretty much, it's more straightforward than that. I'm making this sound complicated when it's actually not really. It's because the terms of this contract will say so. Because when McDonald's is a franchisor, or when the university is our landlord, or anybody enters into a contract, and they're entering into a contract with a small business here, in fact, they know that they're actually dealing with a particular support, group of individuals, right, who are invested in this company. So the terms of the contract will say you can't transfer the rights under this contract to anybody else without our permission, number one. And then number two, it'll say a change in control, or will define a transfer of rights to include a change of control of the company. So if we've got different shareholders here, then we have a deemed change of control that requires our approval. Now, I don't think there is a lease in Melbourne that is with a party who is not a listed company that doesn't have that provision in it. Right. If you're going to let somebody rent your building or bits of it, you want to know who they are and what they're doing in there. Right. So that will it just comes out of the terms of the agreement. All right, let's move over to the other side. I'm just going to flip back to that messy page that we just had here. In theory, I'm going to flip back into it. In practice, clearly I'm not. Oh, here we go. One more. Here we go. So if we're thinking about shares, what's different? So those of you who are buying shares, this group are buying, yeah? No, you're buying.
We're selling.
You're selling. Buying shares. What's different, just given the work that you did to start off with?
Well, we talked about needing to understand the group's structure.
I'm going to open a new page.
Regarding taxation.
So what are you worried about with tax? What would you definitely want to know about in advance?
Liabilities.
Okay, so tax. Going back to tax, what's worrying you?
Well, I guess overall you're taking on all the liabilities of the company, and tax is one of those.
So again, at the early stage, the detail around the tax, I think the bigger picture of liabilities is probably more interesting to you. You want to know what the liabilities are. Do you want to know what the assets are? I mean, these guys just in the last one, they spent a lot of time talking about defining what the assets are, which clearly they need because they need to work out exactly what it is they're buying. Do you need to go to that kind of level of detail, do you think?
I think you need to understand the potential liabilities associated to those assets, financial provision for supporting those assets, so far as loan agreements, etc., etc.
So
I suppose it's less important than spelling out everything you want to.
But-
Because you own it anyway, right?
But if the liabilities are more than assets, the value of the assets, literally the company.
I think we're talking about two different things here. I want to focus back. Sorry, the point you make, Michael, is an excellent one, but let's just make sure we're all on the same page. The question I was asking was, a lot of effort was going into identifying what the assets were that were relevant to the business so they could be transferred, and we're leaving, on the whole, with an asset sale, you're trying to leave obligations behind. You rarely take them on. When you've got a share sale, you are right. Clearly, you're getting everything that the company owns, including its liabilities. So doing a deep dive into what the liabilities are is really important because you need to understand that. But my question is, do we need to do the same level of detail around what the assets are as we might for an asset sale and purchase?
I think so.
Yeah, I think so too.
Okay.
I think in order to value the share offer, one needs to have sort of some implicit understanding of what is.
I think we can even go a step.
structure.
We can go a step even before valuation here. So, if we think about it, when you are buying a business, and I'm going to use business like a layman here, whether you're doing an asset and business transfer or a share transfer, I'm going to call it a business acquisition because that's what you want to acquire, then your client needs to think about all of the things that are needed in order to successfully operate that business. So one of the things it's going to want to do, it's for a different reason, it's going to need to make sure that all of the assets that are associated with making those widgets, selling those hamburgers, developing that software, whatever the business does, are actually owned by the company. So again, if we've got a company and the company is owning a whole lot of assets that do things, what we want to know is that when we buy it, we get all of those things. Because if there's an asset that's sitting over here that happens to be owned by the managing director personally, or, let's say we go and install our software on robots all over the country. We do that by flying in our autonomous car, Learjet, and it turns that's one of the key features that people love about working with this business. But this particular Learjet is owned by somebody else, then we have an issue. So what we're trying to do is make sure that we've identified all of the assets, and that if we need to, we transfer things that aren't currently owned by the group into the group, and we transfer the things that we don't need and that we don't want to continue with outside of the group, so that when we purchase, we only get the things we need, but we get all of the things we need.
We always get this issue with buildings. So manufacturer, might be a food manufacturer, they've got manufacturing premises with glass freezers, storage freezers, refrigeration, and the buyer assumes that that all comes with the business. But in fact, it's a fixture of the building.
Yeah.
If you don't spell it out, you're going to get a nasty dispute later on.
Yeah. Well, in fact, one classic issue where this kind of problem arose was when, I can't remember which way it went around, but there was a transaction that resulted in Daimler Chrysler. So Daimler Chrysler basically owned, among other things, the Mercedes brand. And it turned out after the merger that the actual trademark for the little wheel that sits in the front of Mercedes automobiles was not actually owned by the group that was transferred. And unsurprisingly, the purchasers were somewhat miffed by this, not having the right to stamp the Mercedes stamp on the front of those automobiles. And they had to pay a large amount of money.
That's awesome due diligence for such a large transaction.
Well, you know, I think it was just assumed by everybody. It was just assumed by everyone. And so the resulting litigation was not in Australia, really came down to whether it was there was misleading or deceptive conduct in relation to it.
In private businesses, it's exceptionally common for the business to be carried out in a company and the property to be held by a trust. The trust sometimes may also own shares in the company or potentially not. So that's another situation where there can be differences with what people expect the company to own and what the company actually.
Yeah, but a Learjet is so much more interesting to think about.
But that's like the common one.
It is the common one. You are absolutely right. The
That's for tax structuring.
Well, and often it is very hard for individuals, and for very good reasons, to invest, to use their superannuation funds to invest in their own business. But it's easier for superannuation funds to invest in properties that are then leased to businesses. So that's one of the key reasons why that happens, so that asset connection. But because, I mean, when you think about it, for most individuals, the largest piece of savings that they have is their superannuation savings. And so if you can it can be very tempting to access that money to invest in your business.
But generally you're not allowed, so just stick with your property.
Yeah. Well, I'm also a great believer that you don't want to put that kind of saving, too much of it into one asset. There is a certain amount of risk in relation to that. But when you think about it, the purpose of superannuation is to fund your retirement, and the purpose of investing in business in some ways is it's taking risk for reward. So if you put your retirement savings into your business along, we can have devastating results. So that's the reason for it. Okay, what else? Is there anything else that, from buying shares point of view, I'll go back to the original list, or I won't.
One thing that sort of jumped
I'll go.
was perhaps the regulatory compliances that the acquisition of shares and the voting rights of shareholders might be impacted upon.
So when we're looking at the material terms, at that really early stage, we are probably only saying that the shareholders have the rights to sell, and that everybody's going to promise to do all of the things that they need to do to effect that sale in accordance with the law. What I suspect is more interesting is, let's say this family business that you guys are buying. I'm going to give you a little bit more information about it. So Mum was the founder, loves all her children equally, and basically rarely went home as she's running this business, but she has 12 children. And all 12 of them have a share, but they might have different shares depending on how much they've worked in the business. So some are employees in the business, some of them aren't. 2 of them are completely estranged from the rest of the family, and while they bank their dividend checks every year, they have no conversation. They will not talk to their siblings or anybody else. And we've got a grandchild who's been working in the business for quite a long time, a couple of them maybe, who are expecting to get a share out of all of this. As a purchaser, when we've got a messy, not entirely small register, what kind of things might you be thinking about with the shareholders?
That they've all agreed to.
Yeah. And we'd be also looking perhaps at, well, I need to deal with one person here. I don't want to negotiate with 12 different people who, particularly when some aren't talking to each other. I want to know I can negotiate with one person who can speak for everybody. And I want to have, one set of transactions. All of these people are going to agree to be parties, but how are we going to deal with that? So sometimes that can be quite difficult. So particularly when we've got estranged family members or small shareholdings, and we'll talk about this tomorrow when we get in a takeovers regime, when you're mopping up minorities. So, especially with a business that's been running for a really long time, you might have people who, wrote off their investment a long time ago. They don't even remember that they're shareholders, through to, people who are just pissed off. Like, when businesses are being sold, particularly family businesses, you will have somebody who is just pissed off. And as a purchaser, you don't want to be dealing with that, right? You do not want to get involved in it. And you certainly don't want to be paying your lawyers to sort it out. But it can be a significant issue. So, again, raising that up front.
So is it usually dealt with by an agreement between them?
So usually you'd be looking as purchaser to see that there was either a shareholders agreement that allowed somebody to negotiate or had drag-along, tag-along rights associated with it. You would alternatively that they gave somebody a power of attorney that allowed that person to negotiate. Again, these things are usually dealt with by contract. And you're getting a sense of it. Speaking of which, with shareholders agreements, probably something, if there's a shareholders agreement in place, it would be usual for it to be disclosed fairly early in the process, but as a purchaser it might be something that you ask for, because often they'll contain things like drag-along, tag-along rights, or what we call preemptive rights. So anybody know what a preemptive right is?
Order of priority.
Yeah. Basically, it's usually a right to either meet and match a price or to have a first right to negotiate and offer a price. So if we've got our 12 shareholders and the business, the CEO has decided that it's time to sell, then the business, if we're looking at a share sale, it may well be that there are shareholders who have a right to either make a first offer or, from our purchaser's point of view, more concerningly, to match a price. So from a purchaser's point of view, what kind of issues come up if I'm a shareholder in this business and I've got a preemptive right, a right to match the price that the purchaser has offered?
Well, we can go through all the effort of due diligence and then it's all for nothing.
Exactly. Effectively, the purchaser has been used as or the proposed purchaser has been used as a methodology for establishing a fair market value for the business that was always going to be bought by a particular shareholder or part of the shareholder. So again, one of the things that will often be a material term for a purchaser is that any preemptive rights have been waived. Like, you want to get that up front before you even go to the next stage, that you'll have that waived, which you don't always get. So I'm acting for someone at the moment who sold 75% of the shares in his business to a very large company 5 or 6 years ago. Company has grown dramatically over that period of time. So it was actually structured as an earn-out. I think he sold 25% to begin with, then 50%, then got to 75%. But the purchaser, or the parent company of the purchaser, has since undergone a change of control and there's a changed strategy. And so they engaged some investment bankers to sell this business, or to sell the 75% that they held. Now, the minority shareholder, the original founder, was well advised at the beginning, and the earn-out agreement included a preemptive right, which a right to match, but also it includes what's called a drag-along, tag-along right. So once a price has actually been established, then effectively the person who has that right can either, if they find a purchaser, can either drag along the other purchaser to sell at the same price, or can put their hand up and say, if you can sell, if you achieve that price, you must buy my shares at the same price. And unusually, in this particular case, only that minority shareholder has the drag-along, tag-along. The other side doesn't have it. And there were some concessions that were made at the very beginning for that. You know, all these things, it's a waiting, but it's quite unusual. So, of course, the investment banker right at the very beginning has said, well, we need you to waive this so we can sell our shares. And my client's digging in, saying, well, no, well, why would I? Because effectively, I don't want to sell. I actually think this is good business. I don't want to, it'll only go to a competitor. He hasn't even been working in the business for a couple of years now, but I'd like to go back in and run it again. So I'm going to go and try and put my own deal together and make you sell. And yeah, if you can go to all of this efforts to establish a price for me, that's good. And of course, he's effectively, with only 25%, has completely strangleheld, is that a verb? Their position at the moment. And again, so sometimes these provisions, which seem kind of boilerplate at the beginning, can have a long-term ramification. I mean, I think the original, trying to think when it was, I think the original contract was entered into for the first 25% back in about 2005. So it's quite a while ago now. Anyway. So preemptive rights is something that you guys might be looking at as well. Anything else there? I will let you have a break eventually, by the way. Sorry.
I'd probably like to see some confidence that the business conducts itself in an ongoing manner and profitable manner.
So again, this is something that is really important in both. How the business is conducted before the changeover works really equally across the two. And absolutely that, firstly, what you can control in that intervening period as a purchaser, but from the vendor's perspective, how do we make sure we've got minimal interference? So again, very, very important.
Certain terms perhaps could be written in the agreements to allow certain rights.
So I can't remember in the short form that I gave you, did that have something in there about the contact? Yep, and it had it in both. Yeah. Okay, let's move over and think about it from vendor's perspective with shares. Anything we haven't already spoken about that you think you would need to see in there from a vendor's perspective, or even if it has been spoken about in the context of assets, there'll be benefits in talking about the difference.
Quite basically, maybe the type of share, whether it's priority or otherwise, being issued.
Yep. So what kind of share? So, and particularly if there's a kind of wind up. So, sorry, let me go back 2 steps. One is we've been talking about transfers, so transfers of shares, but another way sometimes of achieving this could in fact be a share issue. It might be an issue of new shares and a cancellation of old shares, or in fact we've just been assuming 100% transfer, but it might be a way of buying shares is to make an investment and become the majority owner or become an owner of new shares. and continue on with the old shareholders continuing on as well. So if when you've got 100% transfer, the type of shares probably doesn't matter, because once you've got 100% transfer, then you're in a position where you can cancel those shares and issue new ones if you need to, if they're not ordinary shares, if they have some sort of preferential treatment or something, basically because you've got 100%, it's probably not going to make a big difference one way or another. It's when you're taking new shares and looking at how that fits into the share capital of the company overall that becomes an issue.
Excluded assets is sometimes an issue, even though you're, as the buyer, you're taking on all the assets of the company. If it's a share purchase, the vendor might have some assets that shouldn't really be inside the company that they need to get out.
Yeah.
That becomes effective.
So, and this tends to happen more often with small businesses. So again, actually, I'm just, looking at this somewhat messy diagram here. If we've got our company,
Like the director's Lexus.
and so again, director might decide I need to take my car, or bizarrely once in a listed company transaction where two parties to the real parties were listed companies, but it was a sale of a subsidiary of one to a subsidiary of another. Office furniture and fit out got excluded. And it's just, somebody who was going to be, who'd been running this business for a while, who's going to be moved into another subsidiary, just who really liked his chair, clearly.
We've had this. I've
It's
had a business owner say he's not having what you think it is.
But it's also just such a lot of fuss and bother. Yes. But anyway, mobile numbers. Mobile numbers can come up in there. These are, I'm probably going into detail now that wouldn't be at that material term stage, but it's just because we're talking about it. Another thing actually that often comes up here for purchases, or actually I'm seeing it come up more and more, is social media accounts. So social media accounts, so your Instagram, Facebook, Twitter, etc., or these days TikTok and Snapchat, that you are happily selling your product and services through, those accounts are opened by individuals. Like, you can't have a company Facebook account, or you can, but it's an individual that owns or has the license to use that social media. So I'm seeing more and more that, particularly with shares sales, but it happens with assets as well, we have to identify who holds those accounts, and even though it is a share transfer, have as part of the completion the transfer of those accounts and passwords. So again, those of you who are thinking more about being personal services lawyers probably turned your mind at some stage to what happens to those accounts and passwords on the death or passing of a loved one too. So I don't know. A good friend of mine died this time last year, and his birthday came up on Facebook the other day. I was like, oh yeah, really, we probably should have done something about that by now. That's not, yeah. Do you want to wish Brady a happy birthday? There's an aside. So anything else that we want to throw in there? I think across everything we've talked about the kinds of issues that come up, and this is, again, an equally common process. I'm not going to step you through it one by one, and again, that orangey colour is very difficult to read on the screen. I apologise for that. It's like the ad hoc coordinated due diligence prior to detailed negotiation. Why do I point out that there are different ways of doing it? This is not legislated, it's commercial. So there is very little magic to these things. Many of these things are just done in a particular order because that is the way that these transactions have evolved. When we get into takeovers tomorrow, there is a legislated process. There is a particular order in which things happen, and if you don't do them in that order and in that way, you risk breaking the law. But when we're talking about private transactions, when we're usually talking about being able to put the number of people that we've got in this room around a table to actually hammer out what the deal will look like, then it can happen. You can agree to do anything that you like. So it is almost 11:15. Are you happy to take a 10-minute break or so, and then we're going to talk very quickly about due diligence before we go and have some lunch, and then we will continue on from there. Cool.